What can we expect from Social Security disability in the year 2020? What has happened, and what are the trends that we can observe, what we expect to have happen going forward? I'm Jonathan Ginsberg. I'm a Social Security disability attorney. And every year at the beginning of the year, I do a video where I describe what's going on in the past year and trends that I expect to see ongoing in the coming year. And so it's time to do that video, so here it is. Basically, the past year, I think the biggest change that I saw was what I would call the full implementation of the new treating physicians rule. And as you may recall, in the past, Social Security had a rule that a treating physician's records were to be given controlling weight. And basically that means if you'd gone to the doctor for 3 or 4 years and that doctor issued a functional capacity evaluation or a letter describing your work capacity limitations, the judge had to accept that except for very unusual circumstances. Well, in 2017 that was changed, and every case, I think it was March 27th of 2017, claims filed after that date, judges are no longer bound by treating physicians. They can accept any medical source, meaning that you could go to a doctor for a one-time visit, a consultative evaluation, or a doctor and Social Security staff, a non-examining doctor, someone who never laid eyes on you. The report from that doctor could be used to deny or approve your case. It gives the judges a lot more freedom as far as what to do, and it does not bind them to treating physicians. Not surprisingly, I think this is a terrible rule. I think they put this into play because there was some corruption with a couple of attorneys. There's one guy in Kentucky who had a big scam going, and basically what was happening was that this guy's name was Eric Conn, if you want to look it up, C-O-N-N. He's now in jail, and I think the judge that was in cahoots with him is deceased, and there was some other people that have been incarcerated. But the bottom line is that this attorney had deals lined up with doctors and other people and judges where he was getting a treating physician to write a letter, and the cases were getting approved, and there was no basis behind it. And of course, this is very unusual. This type of corruption is not at all typical, and I think that Social Security went overboard in basically saying, now we're going to eliminate this entirely. And so what that means is, of course, that a judge can basically say, I can deny you for any reason at all. I have no basis for, I don't have to explain myself anymore. Now, as a practical matter, and getting back to the 2017, any case filed after March of 2017, March 27th to 17, this new rule applies. Well, those cases are coming up for hearing in 2019, 2020, so that's why I say we're seeing full implementation of this. And what I'll tell you from my own experience is I've had a couple of cases denied when a judge ignored, a treating physician who had been seeing my client for 3, 4, 5 years, and they denied the case based on a one-time visit from a consultative doctor or a non-examining doctor. It's rare that this happens, and I think most judges recognize that a treating physician is going to have a much better perspective, much more valuable opinion than someone who's only seen you one time. And look, like there's bad eggs in every business, and I think there are a couple of judges who are out of control out there. Not very many of them, thank goodness, but there are a couple that are outliers, and they're going to find a reason to deny you anyway. This rule gives them a little bit of cover. Again, it's not a widespread problem. It's not something you see a lot. But when you look up on disabilityjudges.com and you see a judge who approves 12% or 15%, those are the judges that are going to use this change in the rule to deny you, and there's basically no grounds for appeal. The big difference is in the past, if a judge ignored a treating physician irrationally or not appropriately, you could appeal it on the grounds that the treating physician rule was ignored. Now that's no longer a grounds for appeal. There could be other grounds for appeal, but big picture, it's not going to change that much. If you have a judge that's intent on denying you, he or she's going to deny you, and this just again is another basis to give that person cover in the past or other reasons why they may deny you. So again, I wouldn't worry about that much. And interestingly, the approval rate nationally has actually gone up. So it went up from 2000, I think it was 45% 34% in 2018. It's 47% in 19. So what that tells me is that judges, in reaction to some of these negative trends, have kind of reasserted their independence. And if a person is deserving, they're going to get approved. If they're not deserving, they won't get approved. So even though there tends to be this narrative in Congress and maybe among some Social Security administrators that the system is riddled with fraud and all kind of people ripping the system off, that most judges don't see it that way. The same issues that existed for the past 10 or 15 years, people that are not able to work, and again, judges are finding a way to get them approved. Now there is pressure, I will tell you, and this is a trend that I expect to see more of, pressure from Social Security to only approve claims where there is a comprehensive and thorough and ongoing medical treatment record, which again sounds great unless you have no money, in which case going to the doctor on a regular basis can be very, very difficult. Like I said, some judges recognize that money is the problem, and that's the situation. They'll find evidence within what's there to issue an approval, or they'll send somebody out for a consultative evaluation and use that to generate an approval. But we are continuing to see more reliance on objective medical evidence, ongoing treatment records. Those cases are going to be a lot stronger. We're seeing an increased focus on medical conditions where the problem can be imaged, an X-ray, an MRI, a CT, as opposed to chronic pain cases, chronic fatigue cases, things where there's no way to image the problem. So again, cases like fibromyalgia, they're still winnable, but you got to have a rheumatologist, and you've got to have a lot of ongoing treatment records, and you've got to have statements from doctors that describe how you meet the American College of Rheumatology criteria for fibromyalgia. You want to have statements from coworkers and supervisors. The evidentiary burden for conditions where there's no test, there's no objective test, have just become higher, just as the evidentiary burdens for younger claimants have become more difficult. So that's a trend. Younger claimants, the younger the claimant, the more evidence you need, the stronger the evidence you need. So we're still in a situation where people that are 50, 55, 58, those cases are going to be easier to win than someone who is 35, 33. If they're 35 or 33, they need to have a serious medical condition, ideally one that can be imaged or tested with objective medical testing, ongoing treatment, support from a treating doctor, especially ideally a specialist, statements from coworkers and supervisors describing what was actually happening at work, and that's going to make those cases winnable. It's just a matter of evidence. You just need stronger and more evidence. The younger you are, the less objective your medical problem is. So again, I don't think there's a huge change in the way judges are evaluating cases, but if I had to tell you one thing that I look for, and that is objective evidence, ongoing treatment records, support from a doctor, and again, non-medical support in the form of statements from coworkers and supervisors. I think that we are seeing more emphasis by Social Security in continuing disability reviews. As before, I think it's more for people who are younger. If you're over age 50, the odds are you're not going to have a significant continuing disability review. If you're younger than 50, those who were approved based on more subjective conditions, the fibromyalgia, the Lyme disease, the chronic fatigue, fibromyalgia, those cases are the ones that are going to be reviewed, because again, Social Security is looking for more and stronger evidence to support an ongoing finding of disability, and realize the big picture strategy here. Social Security knows if you're on a continuing review, if you've already received benefits, that the odds are you won't have a lawyer in the CDR, in the continuing review, because if you choose to have a lawyer, if you choose to, back up, if you choose to have benefits continue, which you've got to do within 10 days of the notice of intent to terminate, then there's no past due benefits. And of course, a lot of people want to have their benefits continue. No past due benefits, no contingency fee. No lawyer is going to take it unless you can agree to pay that lawyer several $1,000s to do the hearing, which nobody has. So it's a way for them to eliminate lawyers, eliminate representation, situation and put you at the mercy of dealing with an administrative law judge on your own. If you choose to have benefits stop, there would be past due benefits, but now you've got to survive for 2 years, year and a half to 2 years while you're waiting for your hearing without money coming in. It's a rock between a hard place situation. So Social Security assumes that most people are going to want to have their benefits continue. Therefore, there'll be no lawyer involved, or it'll be very difficult for people to get a lawyer. So that's the backdoor way they're getting people off of benefits, is by basically putting them on the spot, putting them in a situation where they've got to go to a hearing without a lawyer, and the record won't be as complete as it should be. The documents, the supporting documents, statements from doctors, coworkers, that sort of thing probably won't be there. Now, there are some proposals out there, and people have emailed me about this, from the Trump administration to change Social Security. This is mostly from one of these think tanks in Washington. Let me just say at the outset, I don't think much of this nothing's going to happen in 2020. These things are too controversial and too politically hot. But some of the things they're talking about, so you know, one is to change the grid rules, the medical vocational guidelines, to make them start at age 55 instead of age 50. So that will make it harder to meet a grid rule. They're talking about eliminating the inability to speak English as a factor. So right now, under the grid rules, it's easier to meet a grid rule if you cannot speak English. You're arguing functional capacity. Not being able to speak English is an important factor. They change, if this should change, not being able to speak English will no longer be considered a factor. Does that make sense? Some places, perhaps if you're in an area where most people are Spanish speaking or speaking some other language, not being able to speak English, that maybe shouldn't be as much of a factor. But if you live in a place where there's not many people speaking a different language, if there's not, for example, in Spanish is the one language that you see a lot of people now speaking. If you're in the middle of Maine or in Minnesota, where there's nobody really speaks Spanish on an ongoing basis, it's not something where there's a big community of folks who speak Spanish, not being able to speak English would be a big problem, because you're going to have a hard time finding and keeping a job. But again, this is Social Security doing one of these broad brush type of things. Now again, it hasn't been put into place. It probably won't, but that's one of the things they're talking about. They're talking about eliminating retroactive benefits from 12 months and making it only 6 months, so your past due benefits would only be for 6 months. Again, what that's going to do is it's going to make it more difficult to get attorneys, because as an attorney, we're paid on a contingency. There's risk involved anyway. You're not going to want to take a riskier case where over time, if you have a certain number of cases that are a little riskier, you're going to be less inclined to take them when the amount of money you're earning from this practice area is less, because of less past due benefits. The attorney's fees have not been changed. The standard attorney's fee right now is $6,000, 25% of past due benefits with a cap of $6,000. That's not been changed in 12 years. So again, they're trying to go backdoor to make it harder for people to get attorneys by limiting attorney's fees, making it more difficult for attorneys to take these cases. So that's an ongoing trend that we've seen. So again, I just think there's a narrative in Congress and among some people in the higher echelons of Social Security that the system is just full of fraud, that there's people that are faking it, or they're getting on benefits when they're not deserving, and that there's just billions of dollars are going out the door for people with these very subjective conditions: depression, PTSD, fibromyalgia, chronic fatigue, things like that. And there's an attempt by some in Congress and Social Security to reduce the approvals for those type of cases. Now, obviously, if you're suffering from PTSD, you're suffering from major depression, you've got terrible fibromyalgia, you've got Lyme disease or CRPS, this is legitimate, these are real, and that Social Security should not be trying to eliminate benefits for people who have a real legitimate problem. But again, that's the narrative we're dealing with. So what I would tell you is that the same strategies and tactics that worked before: go to the doctor, find a specialist, ask the doctor for statements regarding your functional capacity and your capacity to perform various physical and mental tasks. that's still the gist of what makes a case a winner. So again, talk to your doctor, get your doctor's help, go to the doctor on a regular basis, take your medications as prescribed. If you can get statements from coworkers and supervisors, that can be very, very helpful. If you've had problems with absences, get copies of your employment records. These are all things that can paint the picture that the judge needs to see to recognize that yes, despite your best efforts and desire to work, you're no longer able to do so on a competitive basis, and the only way you could work would be with special circumstances or in a structured work setting, which is not full-time work. Therefore, you'd be considered disabled for Social Security disability. Hope this was helpful. Please visit my website, ssdanswers.com. Free Secrets to Winning Disability Survival Kit is there. If you like this video, found it helpful, give it a thumbs up on YouTube, like it on Facebook, and reach out to me through the SSD Answers website if you would like a free case evaluation. Jonathan Ginsberg here, wishing you the best. Thanks a lot. Hi, this is Jonathan Ginsberg, and I hope you found this video helpful. If you'd like to know more about how to win your Social Security disability case, I'd like to invite you to download my Secrets to Getting Approved Early Survival Kit that I created just for people like you. Currently, I'm making the survival kit available at no cost, and I encourage you to grab your copy now. Some of the topics I cover include: how do I know if I have a case? Is it the right time for me to file my claim? 9 common mistakes that can doom your case. The 3 must-have arguments you use to win your case. And a topic that every disability claimant wants to know: how to avoid trick questions from the judge. If you or a loved one need to win Social Security disability benefits, you'll find the Survival Kit essential reading. Download your Survival Kit right now and at no cost. Just visit ssdanswers.com/survival and sign up. It's that easy. Please act now. And as always, I wish you the best.